we just do a sound check?
Good afternoon.
All right. We've initiated the live streaming in a few seconds. Trina, you can open court.
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice, presiding.
Thank you, Madam Clerk. Will the clerk please call the case?
This is Supreme Court case number CVA20-013, Levin Titano Camacho, Attorney General of Guam, Plaintiff Appellee versus Daphne M. Shimizu, Director, Guam Department of Revenue and Taxation, Lourdes A. Leon Guerrero, Governor of Guam, Daryl R. Stiles, doing business as D&D Games, and DOES 1-10, Defendant Appellees, and Guam Music, Inc., Defendant Appellant. Appearing for the Defendant Appellant is Attorney Randall F. Cunliffe. Appearing for the Plaintiff Appellee is Attorney Mary Ann Wallachuk. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Cunliffe reserves 7 minutes.
Thank you. Mr. Cunliffe, you may begin.
Mr. Chief Justice, and may it please the court. Public Law 26-52 set forth authorization for the Department of Revenue and Taxation, along with the Cockpit Licensing Board, to create rules and regulations for what they termed gaming within the territory. And that law provided that it would only apply to games that were, or gaming that was licensed as of August 1st, 2001. As of August 1st, 2001, there were a number of various games that were authorized, and they are contained in the rules and regulations prepared. And what was in place at that time? Only those that were licensed as of August 1st could be licensed again. No other machines could be licensed. So we have a finite number of licenses that can be issued. The number is about 300 machines. How can they be operated? Well, they cannot make progressive payouts, and they cannot make direct payouts, have cash or coin come out of the machine to pay off the players. Minors are not allowed to play the machines, and we know that they're not allowed to be placed in any government buildings or any public or private schools. So those standards were already in the law as of August 1st, 2001, and guided the creation of these rules. We believe that sets forth a sufficiently clear standard for the creation of these rules. The courts have said you must have an intelligible principle that establishes the direction to conform, but the agency can make a determination necessary to bring the standard into operation. Essentially, all of the rules and regulations that are of any substance with regard to these matters were already contained in the law. The courts have stated that express standards normally meet constitutional requirements, but laws are also upheld if the courts find implied standards. So the standards we've set forth, we believe exist, and we believe that the delegation of these rules to the parties who actually licensed the various entities was proper.
Mr. Cunliffe, but Mr. Cunliffe, the trial court's decision and order really just focuses on the regulations. It doesn't address the statutes that exist, right? I mean, it really is just focusing on the regulations that were set forth. And I thought that the declaratory judgment that was filed was directed towards the regulations that were transmitted to and subsequently included within the GAR, the Chapter 7 of the 3G GAR. Isn't that really so? I mean, the judge hasn't opined on the validity of the law, but looked at just whether or not DRT was exempt from the triple AAL process, whether that was subsequently validated by the two laws. But it didn't really address, for example, the requirement set forth in 11 GCA 22-002 that you cited about progressive or automatic payouts. So, I mean, we're not really focused now on those existing statutes, right? I mean, we're really focusing on the validity of the regulations, because presumably the regulations added some details that weren't contained in the statutes.
Well, clearly there are matters within the regulations that aren't contained in the statutes. And the question and the matter that was addressed to the court was the delegation was not valid. The delegating the authority to Rev and Tax to even prepare these was not valid. And so we'd addressed the issues in as to the validity of the delegation, but the judge really didn't address that in his decision. But it was before the court, and something that we felt he should take into consideration in making that determination.
So if I understand, Mr. Conley, your argument, you were setting out the statutes because the statutes that existed prior to 2001 had set the boundaries in reference to how Rev and Tax could proceed. And so if I understand your argument, and if this is in fact what you are arguing, is that when Rev and Tax proceeded to enact the regulations, it was not proceeding rudderless, and that is that there are statutory provisions which set standards and boundaries in which Rev and Tax could act, and therefore the argument is that this is not a delegation that runs afoul of violating the separation of powers.
That's correct, Your Honor. We believe that the main aspects of these machines was set forth in the laws that already existed. The number of licenses, who can play, if there's any limitations on where the machines can be located, how their machines can be operated. Unlike Las Vegas or other gaming, the machines are tied together and you have progressive, and they said you can't have progressive payouts, you can't have cash payouts. So, I mean, there's not a whole lot more in the regulation of gaming than those issues, other than some minor issues that they put in. I think the regulations say that the game rooms must be closed from 4 o'clock to 6 o'clock in the morning. That's not something that's going to determine that the rules and regulations are invalid because of a period of 2 hours of closing.
If we were to assume that there was no improper delegation of legislative authority, the argument, of course, that counsel for the Attorney General, one of the arguments points out, is that Rev and Tax just didn't do it right. That Rev and Tax did not follow the AAA in promulgating the rules and regulations, and so even if there was a proper delegation, the regulations were not properly promulgated, and therefore they're invalid. First, that argument first.
I understand that argument, and our position on that is the requirements of the AAA were not necessary to follow because the power is not limited by other statutes under the notwithstanding the other laws clause that were contained in Public Law 2652. So that the legislature essentially told Rev and Tax, you don't have to follow the AAA in order to promulgate these rules. But that isn't, I don't think the problem doesn't end there for the government's position, because the 27th Guam legislature specifically.
Before you get to that, because you just seem to be glossing over that there is a conflict between the AAA and 2652 section 4. the notwithstanding clause or word is that despite anything to the contrary. And as counsel for the Attorney General points out, there was nothing contrary in the AAA that said these gaming devices could not are not legal, and therefore regulations cannot be promulgated in furtherance of any gaming statute. And so if they can be read consistently, wouldn't that suggest, or would that require Rev and Tax to promulgate the regulations in accordance with the AAA, since there was nothing contrary in the AAA to 2652 Section 4?
Well, Your Honor, our belief is that in the cases we've cited, the power was not to be limited. When you say notwithstanding any other laws, the power to create those rules is not to be limited by any other laws, any other statutes. And so they're not limited by the rules and regulations created under the AAA.
Isn't the focus on that on conflicting laws, as the Chief Justice said? So if I mean, why do you need a notwithstanding any other law if the laws aren't conflicting? I mean, it would seem that if there was a conflict with the law, then you would need that language. But if there's not a conflict, then it doesn't appear you would need to rely on that provision. Do you believe there's a conflict between the AAL and 2652?
Well, I don't know why the legislature included that language, and it could well be to tell them that you don't have to follow the AAA to do this.
But they could have said that. We've seen in many instances when the legislature wanted expressly to exempt an agency in enacting rules from the AAA, that the legislature has not been shy in saying that the regulations will be exempted from the provisions of the AAA.
Well, I know that in Public Law 32-60, they specifically said you do have to, when they asked them to do more rules and regulations, they said you do have to follow the AAA. And they had a notwithstanding provision in there. So I don't know how the legislature deems those issues, and I can't speak directly to why they did it.
So you were going to head to the 27-77 issue.
Yes, Your Honor. So even if the notwithstanding language is not compelling to the court, what the 27th Guam legislature did was enacted rules and regulations by the language contained in the law, and that language, all rules and regulations not otherwise acted upon shall be codified and published as provided by this act. So what the legislature did was took something that had been created by someone and enacted it. And when the legislature does that, it doesn't have to go through the AAA. So it doesn't matter that it didn't go through the AAA because the legislature enacted it.
But Mr. Cunliffe, the Attorney General argues that, I mean, you did quote the statute, but there's another provision in the statute, 2777, which it says all rules and regulations or amendments to rules and regulations, then it says promulgated by the director, and then goes through having been transmitted and received. And so their argument is that the regulations that were transmitted on January 3rd, 2003, pursuant to Public Law 2652, were not promulgated by DRT because they didn't go through this public process that DRT would have been required to go through if the AAA had applied. So they suggest that Therefore, this exception within 2777 or this provision doesn't apply to these regulations because they were not promulgated. And so, you know, because of the fact that they weren't promulgated, they don't qualify under that provision. And that's one argument.
Right. The language, I think, it takes that into consideration, Your Honor. It says rules and regulations promulgated by any director and or boards or departments, agencies, and instrumentalities of the government of Guam pursuant to a specific statute or through the Administrative Adjudication Act. And our position is that this was created pursuant to a specific legislation, and the director promulgated these rules and submitted them to the 26th Guam legislature just at the end of the term.
But the power, you think that the power contained in 2652, the Department of Revenue and Taxation, can be read as just strictly the director?
Well, the director, the Department of Revenue and Taxation was authorized to prepare the rules and regulations under 2652. The director submitted rules and regulations to the 26th Guam legislature. They were submitted by the director, George Cruz.
Yeah, on January 3rd. So you read it to say that if you look at 2777, that what it says, it still says it has to be promulgated by the director, but you're saying that promulgated by the director pursuant to 2652. And so you read 2652, which authorizes revenue tax, and you say, well, the director alone could act and promulgate them. And therefore, it's done by statute and not through the AAA. And therefore, since it is transmitted, it qualifies under 2777's exception.
That's correct, Your Honor.
There wasn't any specific reference in 2777 to these gaming regulations at all, right?
There was not.
Okay. And I noticed, Mr. Cunliffe, that you did assert that the intent of the statute was to codify the gaming regulation as the author of the legislation. But was there something in the record below, a declaration by you or some legislative history that had been submitted to support the claim that the intent of the statute was to codify the gaming regulation?
I don't believe there's any documentation. It was discussed during caucus, which is not recorded.
I don't think that's part of the record. So.
Yeah, but you didn't. You didn't file a declaration down below. I didn't see one. I just wanted to make sure.
No, Your Honor, I did not.
Okay, all right. I just wanted to confirm that.
Yeah, I didn't think it would be appropriate to try to add to the record down below, Your Honor. And that's the position we raised, Your Honor, with regard to that argument. Then the other issue is the effect of subsequent legislation to cure any defects. And the courts have held that legislatures may cure or validate previous laws that are invalid or unlawful. So if the court would determine, and the court below could have determined that if this was an invalid law, then did the subsequent legislation cure it? Did 27-77 cure it? And did 32-60 cure it? And I apologize for several times I think it was cited as 30-60 instead of 32-60 in my moving papers, Your Honor, in my brief. I apologize for that. The courts have said that curative legislation must meet two-pronged tests. The legislature originally had the power to authorize the act done or to confer the power exercised. And I think it's clear that the legislature could legalize these machines, pass these laws, and do what is necessary. The second test is that that contracts are not impaired nor vested rights disturbed. And the law that existed that they were acting from, 2652, set forth a time frame that they could legalize these matters. And so no contracts were impaired and nobody's vested rights were disturbed as to the passage of 2652. I've already discussed the language of Public Law 27-77.
The legislature could have, if it wanted to, in 3260, just simply place the gaming regulations that were transmitted to the legislature and subsequently included within the GAR by the compiler into the statute if it wanted, right, at this juncture.
It could if it wanted it, and it could if it thought that perhaps the laws weren't valid. But it's clear from a reading of Public Law 32-60 that they took those regulations to be the law, and they referred to it regularly, and they taxed machines that were licensed pursuant to it.
But
so,
is that really sufficient in recognizing that was, by just mentioning it, by just referring to it, that there is a clear expression that the regulations are valid and properly enacted? Are we to glean that just by mentioning it, anytime someone mentions something, that there is an assumption that it was assumed to be valid in its enactment?
Well, I don't think it's just merely mentioning it in the body of the law, Your Honor. I think that they made some very specific language that addresses that. They said, the legislatura en Guajan intends to place in statute the policies of regulating gaming activities allowed by law, collecting fees and taxes that would be due from duly licensed operators, and making funds available for improvement to the Guam sporting facilities. Another similar section made monies available to the benefit of Guam Memorial Hospital. They went on and said these machines were always eligible for licensures and operations pursuant to 3 GAR section 7114. So they're saying that 3 GAR 7114 is the law. They said the funding for GMH shall be financed by a special tax on machines referred to in 3 GAR section 7114A5, includes Liberty, which are the machines my client operates, symbolics and match play devices registered prior to August 1st, 2001. So it's more than just limiting, saying that they're making a passing reference to these cases and these machines. They specifically—
And where are you reading that from, Mr. Cunliffe? Where are you reading that from 3260? That last section. The section I know where you read where they said the machines were eligible for licensure and operation. That's on page 9 of 3260. But the one that you were just talking about where it identified the Liberty machines.
It's on page 11 of 2260, Your Honor, page 140 of the—
Okay, all right. So it's in 3260 and it's on page 11. Okay.
Yes,
I just wanted to know so I could follow it.
It's the last paragraph. The funds shall be financed by.
Okay, all right. I got it. I see it. Okay.
But I thought the argument is that if things weren't done properly in the past, 3260 made everything okay, and that the legislature expressed a clear, if not intent language, that if there was any problems in the past, we're fixing it, and the regulations are valid. But this one, what you've read, seems to suggest that there was an assumption that everything was done properly and validly. And assuming that's the case, we're going to recognize that. But that's different from saying if something was wrong, we're going to correct it. And this legislation is going to codify what was not done properly in the prior occasion. So which is the argument here? Is that this codified something that was not done properly, or it was done properly in the prior instances, and this statute just recognized that?
Well, I think, Your Honor, if we go back a little bit in the the Act of 3260 on page 7 of that Act, it says the following are the only limited gaming activities authorized in Guam under this Act. And then they say 4, all other limited gaming activities as authorized pursuant to statute. And then that's prior to the 7, where they talk about the Liberty machines and the other machines they're taxing them, and they're clearly saying they've authorized them under this Act because they're taxing them.
Okay, I think there's a little gap there, at least it is in my mind. I mean, you can tax something as a subsequent act, assuming that what it was properly enacted, and that's different from enacting what was not properly promulgated in the earlier instance, and then taxing it. So I'm just having a little disconnect here, and I think in this case provides us with the occasion to determine whether or not what existed in 2001, the laws gave the authority to revenue tax to, or that there existed amusement device that were not contrary to the laws that existed in 2001, then that argument can be made. But I'm just having a little issues with 3260 being the springing statute that brings everything into order, even if it was not done properly in the earlier years.
Well, Your Honor, it's our position that the language in section 2 on page 7, all other limited gaming activities as authorized pursuant to statute, and then their continued reference to the various 3 GAR sections, as well as 11 GCA section 22202, and then specifically naming the Liberty machines, which had previously been licensed under 11 GCA section 22202. And at the time,
again, I guess it goes back to my initial question is that, you know, even if we say, and you look at this language on page 7 that you're talking about, limited gaming activities as authorized pursuant to the statute, I mean, there's no doubt the statute sets forth limited gaming activities that are authorized. I mean, the question is whether or not the machines that are included and were, I guess, authorized by the GAR and set forth, and because even the later section that you talked about, page 12 or 11, talks about when it mentions the device, it says, you know, those registered prior to pursuant to the GAR, so it references the GAR. So the question is, you know, if the GAR was appropriately promulgated and adopted, then it appears that those machines would therefore be included within that. And if they weren't appropriately adopted, then you're not left with relying on the GAR to support the licensure of that machines, and you'll only have to look to the public law as it currently exists. And so, I mean, and that's why when I was looking at Judge Barcinas's decision and order, and I reread that again this morning, you know, the focus for him wasn't really on the statute. I mean, you know, Justice Carbolito points out in terms of the delegation, and yes, it's relevant, I think, in terms of looking at what the statute provides, that at least when you look at 2652, but I was talking about the other statutory provisions, 22202, the authorization in 5205, the definitions within the criminal code of amusement devices and importations in 9 GCA 64. So to me, it goes back to, again, evaluating the regulations and the appropriateness of the regulations and the adoption. When you go back to the authorization as well, Mr. Cunliffe, Judge Barcinas pointed out, the trial judge pointed out, that the original bill had language that said that DRT gaming regulations had been approved by the legislature, but then he dumped that. That was in footnote 4, I think, of his decision and order. But then the final version eliminated that language, and they didn't really focus on whether the regulations had been approved or not approved by the legislature previously. And so the judge seemed to think that there wasn't a express provision in 3260 to approve the regulations that had been, or to cure or validate the regulations. And he basically said 3260 doesn't explicitly state that it was going to cure or validate. And in fact, when the original statute had language that said they had previously approved it, and they took that out.
Well, yeah, and the 3260 even refers back to 27-77 and saying that the legislature had ordered it to be enacted. So, I mean, and I think that deals with some of the problems that I think the Chief Justice finds difficult to deal with. But, you know, hindsight is 50-50. The legislature was taking the position that these were all legal, that nothing was, these machines were legally being operated and the laws were valid. And so there's no need to say, well, you know, in case there's a question of whether these were legal or not legal, we're making them legal, because the language of the legislation itself indicates their belief and their position that everything is legal, but they're passing it on and saying, this is how we're going to go forward with it.
So doesn't that suggest then that the legislature in the 32nd, when it passed this statute, didn't perceive any invalidity in the gaming regulations at all? Because if they were invalid, presumably it wouldn't have said that the gaming devices were being operated legally.
Right. I mean, I think that they certainly believed that the legislation was valid, and they, as I said, they referred to both 2777 in enacting it, ordering it to be codified. And so
but by this statute, they didn't validate those prior regulations, right? So, I mean, it goes back to the question, I mean, that the Chief Justice asked earlier. Does it suggest that if they were under the mistaken presumption that the regulations were validly adopted, but then they weren't? I mean, in this statute in 3260, they did not validate those prior regulations. In fact, the language they use they seem to assume that it was that they were operating legally pursuant to those regulations.
And if they weren't, I think that it's a implied validation by the way they've written the statute.
Now, Mr. Cunliffe, I see that your time is up, but I just want to ask, how is it that Rev and Tax, assuming that all this procedural stuff gets sorted out, the 11 GCA 22202 and 64, whatever it is, 6420B seems to say clearly, it says here, no slot machine. I know we're not talking about slot machines, or amusement devices set to make progressive or automatic payouts shall be licensed under this section, and no gambling device under 6420B shall be licensed. So how do these devices get licensed when we are faced with this statute that makes this expression?
Your Honor, I can tell you that none of our machines meet the definition of coin-operated machines as set forth in 6420 and 6422. And there's case law, plenty of case law in the United States that said legislatures understand the difference between coins and currency. And in similar type of cases.
Those would be factual determinations that's not addressed in this case.
I'm just answering your question, Your Honor. Yes, I mean,
I know, and I'm just saying that that is not something established as of this date in reference to this record. Is that that's that's a query.
Yeah, and I mean, I can tell, Your Honor, I've been greatly troubled and fighting with the whole issue that says, you know, the machines that are licensed pursuant to 22202 of 11 GCA are not controlled by 6410, which is gambling. So, you know, does 6420 apply when 6410 doesn't? I mean, I've been struggling with that whole issue of how that plays out in the scheme of things when they say, well, it's not illegal to wager on these machines and it's not considered gambling. Well, then is the next one saying that it's a gambling machine when the first one says it's not gambling? I don't know.
All right, thank you. Your time is up. And Justice
Thank you.
Merriman, do you have any questions for Attorney Cunliffe?
Yes, Mr. Cunliffe, when the court below issued its order, it voided or invalidated all the licenses. Was that necessary in light of its holding that the regulations were invalid? I just wondered if that order was a little broad or if it's an integral part of the disposition of the case.
I believe that was one of the requests made by the Attorney General in their initial declaratory judgment that the laws were not invalid. And I think, I don't have it in front of me, but I think that they also asked that the machines, the licenses be declared invalid or be invalidated. But yeah, I mean, the only reason the machines were licensed was because Revenue and Tax took the position that the GAR permitted it. I'm just looking at the prayer of relief. It doesn't ask that the licenses be declared void. It just asks that the regulations be declared void.
The reason I ask is if there's still legal machines, as you argue, and they have a license, would it be necessary to void the license or just say no more licenses can be issued, but the ones that are in existence remain valid till they expire? I'm just wondering if the relief is too broad. That's why I'm asking.
Well, the licenses were issued pursuant to the GAR, Your Honor. So I don't think that the court could leave them in place if the court declares that the GAR is not valid, because that's how the licenses were issued.
Okay. Thank you.
Licenses weren't issued pursuant to any existing statute. They were all just issued pursuant to the GAR.
The 300 Liberty machines, the symbolics, and the other machines that are listed in 32-60 were licensed pursuant to the GAR. They were previously licensed by 11 GCA 22202, but the horse race machines are licensed pursuant to 11 GCA 22202.
Thank you, Attorney Cunliffe.
Thank you, Your Honor.
Attorney Woloschuk, you are recognized.
Chief Justice, may it please the court. This is a simple case that has grown complicated because people are reading into the laws what they want to see there instead of what's actually there. The Attorney General is going to ask this court to carefully review the laws, and I think in the end you will agree that the Attorney General was entitled to summary judgment and to declaratory judgment. I just want to respond to some of the points that the defendant raised in his reply brief. First of all, as to the improper delegation, you know, there are no standards in the law. If you look at PL 26-52, you know, the defendant pointed out that it talks about how it's limited to machines as of August 1st, 2001. That's not really a standard. That tells you what the regulations are going to apply to, but it doesn't tell you anything about the goals of the law or what they're supposed to accomplish. If DRT does something that's arbitrary and capricious, how are the licensees going to know? This is the kind of
But
stuff
why isn't the limit on DRT's regulatory discretion the gaming devices that are not prohibited by 9 GCA Chapter 64 and 11 GCA 22202? And then also further refined by the date that the legislature put in. I mean, to me, it doesn't seem that it's an overly or constitutionally impermissible for the legislature to allow DRT to fill in the gaps, so to speak, or fill in the details to achieve the legislative intent. And it seems like this isn't, in my view, something that's just standardless, or as the Chief Justice said, they rudderless for them to do. They're sort of constricted by the dates as well as the existing statutes.
If that were the case, Your Honor, then the regulations would just end up being a copy of the statutes, which kind of is what happened.
It is. I mean, if you read the regulations, at least in this area, I mean, it kind of just sets forth. I mean, there's one other provision about approximately similar machines to provide a way in case some machines broke that they could be replaced. That's in that regulations, because I went back and looked at all those regulations. But and so it doesn't seem to me that it's an impermissibly or improperly delegation of the legislative authority to give DRT the ability to draft regulations that are consistent with the statute and with the and with the restriction of the timing of what licenses were in effect as of a particular time.
If you look at the PL 26-52, Your Honor, it says that DRT is to promulgate rules that create a comprehensive regulatory scheme to regulate all gambling activities. That is very broad. If all they're going to—
But then you have the later ones, authorize and license on Guam as of a particular date. So it does say it has to have been authorized and it has to be licensed. It wasn't like creating a whole new scheme where they could just determine what gets licensed and what gets authorized. The law is there. I mean, they weren't authorizing them to rewrite it.
Let me just clarify that it doesn't say all gambling activities. It says all gaming
activities. Yes, Your Honor. Sorry.
That makes a difference.
Yes. I agree. I think one thing that's being missed in this law, PL 26-52, is that it says it applies to gaming activities that were authorized and licensed. Nobody's looking at authorized, they're only looking at licensed. And there was no authority for these types of gaming devices back then. They may have been licensed, just like more recently they received licenses, but that doesn't mean it was correct. There was no statute that said these gaming devices are authorized. And we're in the kind of jurisdiction where if it's authorized, then there's going to be a law about it, because there was a law about dog racing when that was authorized, and there's a law about cockfighting, and there's a law about carnivals. So if there's no law about gaming devices, then they were not authorized. And so PL 26-52 does not cover them in that clause.
Yeah, but I think the issue is a little different, Ms. Wallace-Jack, because when I read the case law in delegation authority, it's a very low threshold that the Supreme Court has set for that standard to be met, that it constitutes a proper delegation of authority. And so when you look at the cases in reference to the standards, the parameters, I mean, you cited two very extreme cases. One, a model statute that pretty much define the standards in reference to the curb case. And then when you did the military case was the other extreme, where the sheriff wasn't designated. It had to do with the criminal law, and it had to, list what are contraband, and so those are very two extreme cases. But none of the cases said that if it's anything less than that, that it's unconstitutional. And so while the statute seems at first blush to be pretty vague in reference to what standards are being set, when you listen to the argument of Mr. Cunliffe, since it's a very low threshold, that there are statutory provisions that revenue tax could look to in reference to prescribe what is authorized by statute. And we're not only talking about these machines when revenue tax is authorized to regulate, they're regulating bingo, they're regulating other forms of gambling and gaming in this area. So in terms of just a proper delegation, and when you look at the cases, what is fair and reasonable, what are some of the language that's used that are pretty broad, that authorizes the agencies to now go and prescribe a proper meeting to the standards that we have set out. So if you are governed, if we are to look at those parameters, then this statutory provision in terms of go and you are to prescribe the necessary regulations to regulate the gaming activities here in the territory, recognizing that we just don't have a blank statutory scheme in reference to these activities. That doesn't seem to be too far afield of what other case law that has permitted the delegation of authority on the part of the Congress to the agencies, and in this case, the Guam legislature to the Department of Revenue and Tax, in terms of the parallel that is drawn.
Yes, I will agree with Your Honor that the Supreme Court did set the bar low, and that, hasn't found, improper delegation very much like since the 1930s or something. So, this isn't something that is difficult to do. If you look at, however, the interpretation of the notwithstanding clause that the defense is urging on the court, which has to do with, that they are not bound to follow the AAA, that would be an improper delegation, because that means that they've been given the power to ignore any statute if you follow the defense's interpretation of that notwithstanding clause. So we don't think that's the way that clause should be interpreted at all. I've just moved on to another topic, Your Honor.
And that's fine. And that's
okay.
Where my mind is going next too.
Okay. So as I said, the
while you're on that topic, are there any other laws that say DRT can't make gaming regulations? I mean, we talked about the law has to be conflict with the public law. I mean, and that's what you argued that as well, that it's intended to deal with the issues where laws are conflicting. And so is there a law that conflicts with the authority of having DRT promulgate regulations?
I don't know of any conflicting law. I think that the notwithstanding clause and the AAA can be read together, and both can be used in common, and that is something that DRT should have done in this case, instead of just it created some regulations, but it didn't promulgate them. And
but Mr. Cunliffe's argument is, well, if there's no conflicting law, So when the legislature used the word notwithstanding any law to the contrary, it was being broad enough to encompass the AAA process. Because, you know, we were saying, well, it meant to harmonize where there's a law that might have, for example, prevented them from going forward with adopting regulations. And so usually that's what the notwithstanding is, to address when there might be a conflicting law that prevents them from complying. So it overrides compliance with that law, but it doesn't override compliance with a non-conflicting law. And so you know, that was the argument that Mr. Cunliffe says, is there was no non-conflicting law or conflicting law, so therefore it must mean any law. And that's why I asked you, is there a conflicting law that the legislature had to say that? Why couldn't they just come out and just say, you know, in the language of that statute, instead of saying notwithstanding any law, just say the department is hereby authorized to promulgate?
I don't know, Your Honor, why they did it that way. It's created some interesting questions for us these days. But I think that despite, notwithstanding the fact that that clause is there, that the Department of Revenue and Taxation still has to follow the AAA, because there's no other law that would stop it from doing that. Maybe that's what that notwithstanding clause is for. There's nothing to stop those two laws from allowing DRT to use the AAA procedure to pass the regulations. And in fact, that is something that the legislature wanted when it enacted the AAA. It said in one of the sections that it intended to create a uniform procedure for all the agencies to follow, so that everybody is entitled to the same due process when regulations are passed. So there's a notice and a public hearing, there's an environmental impact statement. All these things are done so that everybody has a chance to give some input, which did not happen in this case. So we think those should have been read together, and that DRT should not have ignored the AAA. And because it did, the regulations are not valid. The other thing we were going to say was that the regulations.
Yeah, I want to go to 3260.
Okay.
If I can. The 3260, I mean, there are a number of areas in the passage of that statute that you know, gives me pause. You have in section 1, they talk about intending to place in the statute the policies of regulating gaming activities allowed by law and collecting fees, and Mr. Cunliffe pointed that out, and that's found on page 2 of the statute. Then later on, it says in section 2, which ends up being codified as part of 5202, it defines the gaming activities allowed by law, and then references the statute, or the gaming activities authorized by statute. And then in section 3, it talks about gaming and licensed gaming devices and activities currently in existence and operating legally and regularly in Guam. And then later on, it talks about the regulations, including the gaming regulations found in the GAR. And I think there's one more section of the statute that also says that the legislature finds that these were eligible for licenses and operation pursuant to the GAR. So you have, you know, a number of areas in this Public Law 3260 that suggest that, or may suggest a legislative intent that the some gaming devices would be allowed by law and be regulated by the government. I mean, you know, there's a lot of language in that statute that that seems to suggest that.
Yes, Your Honor, we agree. We saw that language there too, that the legislature has this intent to have a policy of regulating gaming devices. The thing is that all the things that they said in 3260, those things don't validate old regulations that were not properly promulgated. Those regulations are still flawed. And you know, they had stated earlier, I think Your Honor pointed this out, you know, the earliest version of the bill said that that, you know, they were recognizing those regulations as valid, and then our office submitted some I think a letter that said actually they're not valid, and so that was taken out of the bill, and it didn't make it into the statute. So they knew how to do it and they didn't do it, which means they didn't want to do it. It means that they did not validate the regulations using this statute. All they did was, if you look at that list of activities that are allowed, there's the catch-all at the end, but these gaming devices don't fall in there because they were from before, you know, I think they were as of August 1st, 2001, but there was no law that authorized them. If you go back to 26-52, it has to be authorized and licensed, not just licensed. So this new law did not fix it, and neither did 27-77. That was another one that did not fix it. And I know that the defense took us to task for calling it, you know, promulgating regulations by stealth, but we really think that that's what was done here, because if you look at the record that goes with that statute, you will see that there is oral testimony from a couple of witnesses. There is written testimony from the AG and from Chief Justice Carbolito as he was then. And all they talk about is transferring the function of the compiler from the AG's office to the court, and they talk about the budget and all that kind of stuff. Nobody said anything about this is going to validate those gaming regulations, by the way. So, you know, that's what's going to happen here. There may have been a public hearing, but nobody knew that that's what that law was going to do. That's not what happened. So we would say that Public Law 27-77 also did not validate those regulations. In order to have the regulations validated, you still would have had to follow the AAA. And here, DRT did not do that. There was no notice, there was no hearing, there was no environmental impact statement. So the regulations are not valid. And I will see if I hit everything.
So Mr. Cundiff points out that that the machines that are licensed now are not slot machines or amusement devices set to make progressive or automatic payouts as prohibited under 22-202. He suggests that these machines were licensed previously under 11 GCA 2202, where the license fee was imposed on amusement devices, and they don't fit within the definition of a coin-operated device to be prohibited under the gambling provision. So he argues that, you know, there is still a authorized amusement devices, which some of these devices can comply with under the law currently, and maybe even irrespective of whether the regulations are voided. And that goes back to Justice Merriman's question. You didn't, in your claim for declaratory relief, request that all of the licenses be voided. but the trial court judge in his decision, not in the decision and order, but in the actual judgment, because he doesn't reference it, said any electronic devices issued pursuant to the GAR are void. And then, but I guess he doesn't reference devices that are issued pursuant to the law, if any were. And Mr. Conlon, I'm not sure if any devices were authorized just all to the GAR or whether they were authorized in part by the statute. What is your position on the breadth of the judgment and the licensure?
Okay, so Your Honor, what we did ask for in our first amended complaint, which I'm trying to find the page number in the excerpts of record. We did ask for the licenses to be revoked and for no new licenses to be issued. So that is
That is correct, Your Honor. I misspoke. It's in their amended complaint on page 20 of the excerpts that we filed.
Yeah,
That's
okay,
right.
It was, yeah. Yeah, it wasn't in the original complaint, but it was in the amended complaint.
Yeah, we added it, Your Honor. So we expanded what we were looking for because it made sense. Because if the regulations are no longer valid and they're void, then these licenses should be as well, and nobody should be licensing these gaming devices. The other question that Your Honor was talking about, that issue goes back to, as we were saying, that these gaming devices may have been licensed, but they were not authorized. There was no law that said on August 1st, 2001, that said these gaming devices are authorized. There were all sorts of other activities at that time that were authorized. The cockfighting and the dog racing and the carnivals, I think, so on and so forth, but not these gaming devices. It's been the Attorney General's position consistently and all throughout that there was never a law that authorized these, and they never should have gotten licenses in the first place. And so for them to be getting licenses pursuant to void regulations, that's just like doubly wrong. These are things that should not be happening. And just because they happened doesn't mean that it makes them valid. As I pointed out, that, in later years, one of the reasons why our office started some of the litigation in 2008 and 2009 was because, we told DRT what the status of the law was. They agreed with us, and they turned around and issued the licenses anyway. So that's why we did, I think, petitions for writs of mandate in those types of cases. And then finally, I think we decided that a declaratory judgment would be the best way to finally get an answer to what is the state of the law, what should be happening. And we think that we are entitled to summary judgment, we are entitled to declaratory judgment, because these regulations were invalid and the subsequent laws never validated them, and these gaming devices were not authorized. They don't fit in with PL 26-52. That statute does not encompass these gaming devices. If that's all, I will end now. Thank you. We ask that Your Honors affirm the court below.
Let me ask this, Ms. Wallace-Chuck, but if we strike down the regulations, that it was properly promulgated, do we reach the issue as to whether or not there could be licenses that are authorized under the statute? I mean, you just asked us to address the regulations. You asked for the Attorney General asked for a declaratory judgment that the regulations were not properly promulgated. So if that is declared, and because of it didn't follow with the AAA, then that's the case before us.
Yes, that's right, Your Honor. I think the judgment below reflects that. There is a declaratory judgment in the final judgment that was filed in this case. And,
So
and
we don't reach the issue as to whether or not there could be licenses or devices that are authorized under the statute and may be properly licensed.
We would say, Your Honor, that there aren't any. There is no such law that would have allowed that back then. I mean,
But that's not this case, is it?
I mean, that's what we've been saying all along. That's just
the declaratory relief was just focused on revoking the licenses that were authorized pursuant to the regulations. So, and that was essentially what the judge ruled upon. He didn't rule on whether or not there might be licenses of other machines that may be licensed under 22-202. That could be an amusement device that's not a slot machine, or an amusement device that makes progressive payments, and it's not prohibited, as Mr. Cunliffe was arguing, because it's not coin operated under 6410. So, you know, there may be a gray area of whether or not there are some devices that are not going to be voided as a result of the regulations. And I don't think we were in a position to address that on the record that we have before us now.
Yes, that's right, Your Honor. I think those devices are something different from the devices at issue in this case. The devices at issue in this case were ones that were improperly licensed according to the regulations, not some different kind. If we were going to go into whether they're gambling devices or something, that was a separate issue, and that would have required you know, more fact finding, which is something that we were prepared to do. But, you know, we didn't have to reach that because we got summary judgment on this issue here.
All right, I just wanted to that clarification and see your position on it. Any other questions for Ms. Wallace-Jones?
I have no questions.
Justice Merriman? All right, thank you. Thank you, counsel.
Thank you, Your Honor.
And Mr. Cunliffe, you did use all your time and more. So the court will take the matter under advisement, and the court will stand adjourned. Thank you, counsels.
Thank you, Your Honor.